Good morning, everyone, and happy Vasant Panchami to everyone. Very
Yes,
good day today,
Good morning.
very good day today. Yes.
and thanks everyone for showing your interest in the topic and our underwear. Today's topic, honestly, I selected, and when I was going through with Brinda, there are certain questions which is questions only. And I was also thinking that how this will be taken. And today, again in the early morning, I sat and I started convincing myself and understanding. So, honestly speaking, though little out of box for many CS, this topic, but it's really interesting. And when that earlier amendment happened, in this provision of foreign company, whereby even a virtual mode was added, at that time, many questions arose, and honestly speaking, still that questions remain. So basically, this topic of companies, if you read, it is foreign company, but to chapter 22, they have mentioned company incorporated outside India. But we read the inside the chapter, they say company incorporated out of India, but they are going back to foreign company. So that's why we have made it foreign company. And foreign company, what it basically, if we, after understanding the provision and all that, I can say that what government intends is that any company or body corporate incorporated out of India, if carries out any business activity, then government should know that activity, the company overseas which is carried out any activity, the details of that, and what are the outcome of the activity, and the government should be able to communicate. The government should be able to communicate with the said person, and there should be some person responsible so that government can catch hold of that person for any compliance. So, in short, any company incorporated out of India, if carries out even a market research, it's a data of this our country, they can't do it without intimating the same to the government. Why they are doing, what purpose, and how they utilize. Because it should not be misutilized. And that is the duty of government and right of government. And they are subject to the law of land when they do any activity in India, including market research. So they should be made responsible. And that is the provision of this. If we understand this concept of or idea of government, that any company, corporate is doing any activity with the intent of business, relevant to business, then boss, you have registration here, you have one person here whom government can contact, you give the information of that activity, and if and give the detail of that foreign company. And with that, my comment, I will start this our today's session, and I welcome our two panelists, Ms. Silpi Thapar and Ashutosh Nayak. Both are my old friends, and of course, Ashutosh is our ex-Meta, my proud ex-Meta member. To introduce Silpi, it's a very big profile, a lot of achievement in her career.
Not bigger than you, Ritti.
She looks young, but she has achieved lot many things like old people like me.
I'm young, please.
You are young, I am telling you.
Who says you're old? Huh?
So much.
Then what should I say for myself?
That's right.
You are teenager, sir.
Young by heart.
When I'm with you people now, I feel 40 years younger.
Yes. Age is just a number, sir. Age is just a
So,
number.
Silpi is a CS, associate member of ICASA. Silpi is a fellow member of ICICI. She is also qualified insolvency professional. She is associate member of ICSA, Institute of Chartered Secretary Administration, England. She is a lawyer. She is independent director of various companies, including many public sector companies. And she is also honored as a Doctor of Excellence honoris causa by Confederation of International Accreditation Commission. Received Award of Excellence by World Peacemaker and Diplomats Global Organization. Received Woman Appreciation and Achiever 2013 trophy from Ms. Smriti Irani. She is practicing as a CS. She has overall experience of 19 years, including 14 years in practicing. Specialized in corporate law, IPR, corporate governance, board process, legal drafting, corporate restructuring, director training, etc. She is the first lady chairperson of Ahmedabad chapter, authored various articles on corporate law for Gujarat Chamber, ICICI, Charter Secretary, contributed various corporate papers on corporate law, corporate governance, international and national conference. She is regular speaker in the Directors Training Program and other national conferences held by IOD, CII, ICSI, ICI, SOCHM, United School of Law, etc. So long profile, Silpi. Welcome to our this program. Thanks for your time.
Thank you, Dipti. It's my pleasure. Thanks for inviting me.
Very impressive. I'm highly delighted.
Thank you, sir.
We have another panelist, Mr. Ashutosh Nayak. His profile is very short and sweet, Ashutosh. He is a compliance professional with more than 21 years of experience in managing regulatory, governance, legal, and strategic matters. He heads compliance, legal, and secretarial function of GROW Group. Before joining GROW, Mr. Nayak was heading compliance at IIFL Wealth Management and was one of the key persons involved in launch and growth of various business, including mutual fund, AIF, distribution, research, portfolio management, advisory, lending, broking, both in India and offshore. He led the compliance role in launching and managing compliance of various AIF schemes, leading to the creation of largest AIF in India. He led the secretarial role of IIFL Wealth Group companies and successfully assisted the group in listing IIFL Wealth on stock exchange. Mr. Nayak is a member of ICICI and a bachelor in degree in law. Welcome, Ashutosh. And I will now request both the panelists to give Mr. Bala to give first introduction for 2 minutes on the topic, and both the speaker to say on this topic for some time, and then we'll start the session. Over to Mr. Bala, please.
Good morning to all of you. I have a pleasure in welcoming you all for this session on my own behalf and also on behalf of Mehta and Mehta. And today's topic is such a topic which actually throws a light the total change in their life. Really speaking, who would have imagined that we will be meeting on the online like this and we will be discussing about 20-30 years back? No one. Because we all used to be physically, now we are actually on the online. And similarly, I think Shailesh will recall it. About 30-40 years back, when we want to get imported material, we have to actually find out where the duty-free imported shop opened by the government shop. We have to find out and we have to go. That is the way we were actually finding out.
Yes, correct.
Now today what happens? By sitting at home, you have a visual, you open the site, you see Amazon, Flipkart, Snapdeal, anything, whatever things are there available, you can just select. It is just delivered on your home delivery. The life is drastically changed. The business is changed. Everything changed. A lot of foreign companies, they are using the web-based platform and they are doing a business. when they are doing a business in India, then naturally they have to govern by the Indian laws. They have to actually comply with the Companies Act of India. They have to comply with the taxation rules. They have to comply with the custom duty rules. All other rules, they have to comply with it. Because the drastic change in today's way of doing a business, sitting anywhere, any place across the globe, has actually changed the total outlook of the people, business, everything. So that means if you are doing a business in India, it is not necessary you need to have an office established here. You need to have a place of office, or you need to have some business activity, but you can have your office situated elsewhere in the globe. That is what it means. But nevertheless, the compliance is very much important, because Dipti Madam said it very clearly. The government is actually interested in knowing what are the people who are doing the business. Are they complying with the laws? Are we getting the due revenue to the government? These are all very, very important matters. Of course, in the 1956 Act also the foreign company was there, but the only thing is the foreign company activity is not very much what we are seeing today. Because those days, e-commerce, never heard of it. E-commerce is the latest development. So when the 2013 Act has come, subsequently the amendment which has come, we have seen now, the foreign companies' scope has been very much widened. Compliances have been widened. In fact, we are actually switched over from providing the information to the government in the old Act to complying with the regulation in the new Act. Yes. That is a great change has taken. Because for your information, viewers, in the earlier Act, if the foreign company created the charge, they need to only intimate to the government, they need not to be registered. But in the 2013 Act, that is not the case. In 2013, they need to register. Similarly, foreign company can establish various type of the offices in India, like they can open a branch office, they can open a license office, they can open the project office. But there also there are compliances are there actually. Within the opening of these offices, they need to give intimation to the government, and they also need to file periodical returns. All these compliances are actually there. And today's session is actually going to be very, very interesting, going through the various aspects. What are the compliances are required? What are the governing rules are required? If they want to expand, if they want to raise capital, if they want to do the merger, etc., and all this thing, what are the various provisions? So I think the presentation is going to be very interesting. And added to that, we have to do the expert panels on this, who will be sharing their practical view of this subject. We will be benefited to hear from their well experience. Over to Shilpa.
You are on mute, Shilpi.
Thank you, sir. I think you have covered most of the, the features of foreign company. But just a short introduction. Now we know that there are various kind of companies like public, private, government-owned companies, that operate in the country. And depending upon their specific nature, suitable rules and regulations have to be formulated for each kind of company. Now, each country has particular rules and regulations applicable to the homegrown company. Similarly, if any company wants to operate in a country other than its home country, it has to follow the rules and regulations of given local country and even the home country where it is incorporated. So in India, the foreign company is mandated to follow certain special and modified provisions as compared to the domestic company. For instance, a foreign company at the time of making investments in India or setting up an office is required to comply with FEMA. Similarly, the foreign companies are involved in selling the goods and providing services, then it has to follow the Indian tax laws. So a foreign company, in short, is an entity which is incorporated outside India, but has a place of business in India or conducts any business activity in India in any other manner. I think companies at 2013, has broadened the scope has been broadened for the foreign companies. And I would mention here a very two important case laws. I think these are the case laws which are considered by amending the provisions of foreign companies under new act. I think in the presentation also one case law is covered, that is Willis Europe BV versus Willis India. That is in older companies like section 591(1). The crux of this case law was that The section 591 subsection 1 applies not to the company that carry on business in India, but to companies that establish places of business in India. And the second one was also very important. It was of Delhi Dabur Nepal Private Limited, in which the High Court says that the company would be held to have established a place of business in India if it has a specified or identifiable place at which it carries on business, such as office, storehouse, godown, or other premises, having some concrete connection between the place and the business. So 1956 Act stressed on the physical presence of business, but due to technological boom, various companies are operating in the country without having any physical presence. So that is considered in the amended 2013 Act. Plus, four important amendments are there. In 1956 Act, only companies was covered. But in this, the corporate and body corporates and corporation is also covered under the new Act, under the foreign company definition. Electronic means definition is very important, which includes all online services like email, mobile services, cloud computing, social media. So if the main server is outside India, it would still, be considered as a foreign company, and it has to follow the provisions related to the foreign companies. Second important definition is place of business. So even if foreign e-commerce website is based outside India, not having any office or employees in India, and if any Indian resident place any order on that website, it will be considered as a foreign company and has to comply with the provisions. Even media and broadcasting business, for example, there was a case of Zee Entertainment Limited. It is having a subsidiary outside India, that is Asia Today. So they also, under the new Act, they are also under the ambit of the provisions for complying with the provisions of this Act. So I think Vrinda has made a very good presentation. He has made a comparison between the old Act and new Act. So many things are covered in that, and we will get a proper clarity on that.
Thank you. Ashutosh, please.
First of all, thank you so much for giving this opportunity to be on this platform and exchange the ideas. I think this is something which I think we read lots of provisions, acts, but somehow miss on some, like chapter foreign company, chapter 22. I really thank for this platform, and especially Vrinda, the way she explained me the round of, I really, I was thrilled to understand each and every provisions, case laws, and thanks for allowing me to be here. So I came little prepared up post that presentation. Thank you so much for that. I think very important thing is that I think while we have seen gone through this circulars, what the important thing we need to notice that not every foreign company is getting attracted by this, right? First of all, we'll have to see that if there's a 50% stake in that company by Indian citizens of India, then it gets triggered. So for example, if it's Alibaba who's selling a product in India, correct me if I'm wrong, but if Alibaba is selling a product in India where you're able to access to that website and get some delivery of business, still it doesn't get triggered because we don't own more than, or Indian citizens don't own more than 50% in that Alibaba group, my understanding is. But yeah, being now in this fintech industry for last 14 months, I have seen this eco culture really growing up, where lots and lots of Indians, I think this Indian community or Indian eco culture is really growing up. Businesses are really, I'm sure the people on this platform or the participants have seen Indians now investing outside India. It's a reverse flow which is happening. Lots of tech startups are investing outside India, where they take a good stake in foreign companies and create this platform to come back to India and do business in India. So that's a good amount of entrepreneurs, youngsters, startups, VCs are doing that. So I think this section gets really, it seems now very important from a perspective. How do you technically take guidance of all professional consultants like of various firms or tax councils for this particular purposes. But the larger thing is that I'm sure I'll also have to consult now after reading this, is that, while place of business is defined under, as Vrinda mentioned, under Income Tax Act, but it's larger, like, even if you have a stake in a foreign company, which of more than 50%, right? Whether it includes business done through wholly owned subsidiary, whether that's place of business in India or not, whether if foreign company doesn't do place in India, doesn't do any business in India, but it has a trademark registered in India. So all Indian companies have, suppose has a holdco in US, for example, we do have, right? And that foreign company is holding trademark in India, whether that's place of business in India. Okay, it doesn't have place of business in India, but it is charging royalty to an Indian entities for for using the word brand or something of the US entity, whether that's place of India and India. I think a broader it opens up lots of discussions, and quite excited for this session today. Thank you, everyone, the panelists, the co-panelists, Brinda, Dipti ma'am, Balakrishnan. Thank you. I think that's my initial thoughts to start this discussion. Thank you.
Thanks, Ashutosh. You have opened Pandora box of that holding subsidiary. So we will take that during the session. And I think we have created a business for a law firm for your organization by taking this session.
Sure.
Okay, Brinda, please start the session. Brinda?
Sorry. A warm welcome to all the viewers. I'm Brinda Poddar, and I'm thankful to Dipti ma'am for giving me this opportunity to present on a, like you said, a Pandora box kind of a topic, that is foreign company. So we are taking this topic because of primarily, I think, two reasons. One, with this digital world that we have stepped into, and a lot of people working with organizations which have a presence globally. So one is to understand whether they constitute as a foreign company under the Companies Act, and then to see whether what all compliances they need to perform. So in order to understand whether they need to comply with the requirements of the Act, we first need to understand whether that is applicable to that company. So I'll proceed with first understanding what a foreign company is. A foreign company is defined under the Companies Act 2013 in section 2, subsection 42, as any company or a body corporate which is incorporated outside India, that is in any other country, but it has a place of business in India and conducts any business activity. The key word here being and. So that company needs to have comply with both of these points. It needs to have a place of business and it needs to conduct a business activity. Now, this place of business the company can either have by itself or through an agent. It can either have that physically or through an electronic mode.
Vrunda, one minute. You have stressed on the word and. Huh?
Yes.
But when you look at B, it says conducts any business in India in any other manner.
Yes.
So when you say in any other manner, if you are conducting business under A, etc., if it's beyond that, then that B will come into picture. In A itself, it is there, no? A itself is self-sufficient. I'm just thinking out of the box.
Yeah, I get it. So, sir, what I feel here is that establishing a place of business in India. So, for example, if a company based out of Singapore has just opened up an office in India, it can be said that they have a physical place of business. But if that company is not doing any kind of activity in India, then it would not be constituted as a foreign company. So that
I agree. But the words used are conducts any business in India in any other manner.
Yeah.
The word, there is no or and between that India and in.
Yeah.
That, Bala, sets me thinking whether A by itself is self-sufficient. Because conducts any business in India in any other manner.
No, see, there are a couple of things. The any other manner comes into the picture. You can do the business regularly, you can do the business only for some time. For example, if you know, in the Act itself, it says the foreign companies can open a branch office.
Yes.
And a foreign company can open a license office. Foreign company can also open a project office.
Yes.
Now what happens is, if you are actually having a business activity on an ongoing basis, it's fine. But when you open the project office, then what happens is you are doing a business only for the particular restricted period. This is also a business, but it is not regularly going to be there. Once the project gets over, the business is actually done. They cannot do any other activity.
Actually, this B should have been split up into B and C, you know. The B should have ended at conducts any business activity in India. Pause there. And then take C, or conducts business activity in India in any other manner.
Yeah,
Yes.
because there are different type of establishment can be done. Now, for example, if you do a license office
Yes.
office cannot do any business at all.
Yes, correct.
It can only collect information and send the
And
things,
pass it
etc. and other things. That's all.
Yes.
But
Yes.
when you open the branch office, yes, you can do the business related activities. If you
Okay,
open the
sorry.
project
I
office,
think I deviated unnecessarily. Come on, Brinda, please carry on.
Yeah, there has to be, sir, there has to be some connection between the business and, business activity and the company incorporate outside. I think the crux is that.
Basically,
Therefore, I felt that in any other manner should have been covered in a C.
no,
The act should have covered it.
Shailesh
Okay.
bhai,
Anyway, let's go ahead, please.
No, that's a very,
Please.
actually, that's a very good question, actually. It's need an interpretation. I agree with
This
you.
definition is only going to we discuss lot and lot. Compliance is there. That's why again I'm coming. It says any company or body corporate means anything. For us, body corporate is defined.
Yes.
So society and individual and is are out. Which has a place of business in India. Now, place of business in India is also defined. Okay? No, it
Yes.
is not defined. That is a Pandora box.
Yeah.
Okay.
Whether by itself. Okay? Place of business in India, whether by itself, that foreign company, or through an agent. So he has appointed some agent and he is having office then. Physically, that is physical. Then he is holding an office physical or in electronic mode. Either of it.
Shailesh bhai, the
Now-
moment you say place of business, even if you have a godown, warehouse, it's a place of
Yes.
business.
Yes,
So-
What Amazon is doing?
So in electronic mode also.
Yeah.
Okay, that is the main change happened earlier. And why they are telling and conducts any business activity in India in any other manner. So suppose they set up a office or a place of business. In that case, they require to comply FEMA. But if they start the activity, then they are foreign company and come under Companies Act. Of course, in FEMA, if you set up any that liaison office and all that kind of branch office and all that, we have certain compliance. That is different. But if they comply, means if the activity started, then foreign company and this process. And that's why conduct any business activity in India in any other manner. So they are telling in any other manner, whether in the way I have prescribed earlier in A. In addition to if you think anything else, they are predicting they may be doing something else. In any other manner you do, you are foreign.
Very, very true, Dipti. But I would say better drafting or cleaner drafting would have been to shift that in any other manner into A after electronic mode, because it
Right.
deals with that way of doing business. And leave B at conducts any business activity in India. So I would read it, which has a place of business in India, whether by itself or through an agent, physically or through electronic mode, or in any other manner, and then and conducts any business activity in India. That in any other manner is misplaced at the end of B. Of course, it's law. We have got nothing to do with it. But just I felt in any other manner is not in the proper place.
Okay.
There
Brinda,
is a question is there in the chat box. Conduct the business through the subsidiary company can be included in any other manner.
that is the only thing which Ashutosh also raised the question.
Correct, in the beginning.
Let this definition presentation complete and we will take
Yes.
all the question put in chat box. I think otherwise it will be There are a lot of question in this definition itself. So let
Sorry, Brunda, for making this deviation. So sorry.
No, it will
So,
happen.
we are here for a discussion, sir.
No, don't
Brenda,
worry.
Your views.
Brenda,
It's fine.
go slow on each word because each word is crucial in this
Each
definition.
word is crucial, correct.
Yeah, please, Brenda.
May I move on to the next slide?
Yeah, please.
The next is a Pandora box, that is place of business, which is not clearly defined in the Companies Act, but there's a definition in the Central Goods and Service Tax Act. It goes as a place from where the business is ordinarily carried on. It includes a warehouse or a godown or any other place where a taxable person stores his goods, supplies, or receives goods and services, or both. So basically, in the GST Act, it says that the business has to be first ordinarily carried on by the company which is incorporated outside India. It should have a place in India where it carries on business. That place can be a warehouse or a godown or any other place where the taxable person can store his goods or supplies, basically a place where they carry business out. It can be physical, it can be electronic, like we saw in the previous slide. It can be a place where the taxable person maintains his books of accounts, and it can be a place where a person is engaged in business through an agent by whatever name called. So directly or indirectly, if a company which was incorporated outside India, if it has a place in India where it carries on business, it can be said for the purpose of GST that it has a place of business in India. However, the Companies Act in section 386 gives an inclusive interpretation. 386 section is for interpretations. It says there that a place of business includes share transfer or registration office as well.
Ma'am, can I ask one question regarding this?
Yes, sure.
Yeah. If suppose a foreign company which is having an agent in India, the agent is getting the order from the another company. Let's example the foreign company which is based on Switzerland, but the order is getting from, let's example, any UK company, and the services provided at UK, not in India. Let's a software company. So they are providing the services at UK. So how will define whether it will be a being place of business will be in UK, but the order is executed through the agent of a foreign company which is situated in Switzerland. So should we consider it as a foreign company, or being the transaction is through their agent who is in India?
So if I clarify, the company is in Switzerland, the agent is in India physically, their authorized agent.
Yes, ma'am. Yes.
And the order is booked for UK company and executed there.
Yes, ma'am. Yes.
What is your view first?
My view is if we'll see the definition of this services under now it is supply under the GST Act, so it is considered as the export services. So if we'll consider the export services, then it should be a foreign company transaction.
Right. Your agent,
Yes.
authorized agent you appointed. That's why I specifically asked authorized agent.
No, only Dipti ma'am, the confusion was being the company situated in Switzerland. The order is executed in UK, but it is executed through the agent who is in India.
Exactly. So
Yes.
this transaction would have not happened. Don't you think this agent has done a very crucial job? He is part of the transaction. He got the order. It's a business activity. Your agent
Yes.
is,
Yeah, definitely.
I agree.
Yes.
I agree with this.
Yeah. Thank you.
But Mahesh, I want to just question one thing: is that agent booking any revenue in India?
Yes, definitely. Once the order is executed, that's why it's a confusion, because the foreign currency is generating in India, and the transaction, the Switzerland company is getting the money, whatever maybe some commission or some profit. but some part of profit is keeping it in India, and the foreign currency transaction is routing through India. That's why it was confused in my mind.
No,
I think the bottom line is that we have to establish some connection between the place, business, and the company. So there is some
Yeah.
connection. It will be covered under the provisions of this particular section.
No, ma'am, but it's a connection between agent is
Yeah, it's a
authorized
connection.
agent.
That's what I'm telling.
Yes.
No, the between
Yes,
person
yes.
is there, so it will
Yes,
be covered.
yes. Yeah, yeah. Thank you, ma'am.
Actually, Mr. Bias, you have answered yourself question, but you
No,
just.
No. Just I would like to get the confirmation from the
Exactly, I-
expert person like you.
Arey Baba, we all are expert and we all are learner. See, this is the beauty of this session. We want to discuss only.
Yes, ma'am. Yes.
We
ma'am.
learn from you and everyone
Yeah.
learn from each other.
Correct. Yes, thank you, ma'am.
Thanks
Thank
for
you.
your question. Yeah, Brenda.
So in the first slide, in the definition of foreign company, we saw that a place of business can be physical or through electronic, because we live in a very digital world. So not necessarily that all businesses would require, tangible assets, or there would be products. There could be services, which don't require any warehouse or a go down. It could be completely electronic. So the electronic mode is also defined in the Companies Act. That includes business to business and business to customer transactions, that B2B and B2C transactions. There could be data interchange, there could be digital supply transactions. The foreign company could be accepting or inviting deposits.
Brinda, slow. Each one is a very crucial activity. Please slow. Everyone has to take in mind. It takes time. You have digested. Everyone has to digest.
So I'll start over. There could be B2B and B2C transactions happening over an electronic mode, over email, mobile devices, over social media, cloud computing, any kind of electronic ways. So there could be B2B and B2C transactions. There could be data interchange happening digitally. There could be digital supply transactions happening. The foreign company could be accepting or inviting deposits or subscription to securities in India. Financial settlements could be happening between the company incorporated outside India and maybe an entity in India. There could be web-based marketing that the company incorporated outside India could be doing. It could be providing advisory services online. It could be providing database services online. Supply chain management could be happening completely through an electronic manner. Telemarketing, telecommuting, telemedicine, all of these are included in electronic modes. So basically, if there's any business transaction happening over email, through mobile devices or through social media without actually having a physical resource located in India, that is called as having a place of business in an electronic mode. The server here for the electronic transaction need not be in India. It could be in India or outside India. That becomes irrelevant, but there has to be a transaction happening. A couple of examples for places of business which have an electronic mode. There's a company, HiQ Solutions Limited, which was incorporated in the UK, but has a place of business in India in electronic mode. This is because HiQ India is engaged in the business of providing intelligent work solution, legal work solutions that simplify the legal process and combines the whole, liaising between a client and a customer, a client and the service provider, and it's all automated. Right from documentation to collaboration, the whole process that is done electronically. So they have a registered place of business in India. They have a FCRN number. So it can be said that HiQ Solutions Limited has a place of business in India solely electronically. One other example is of Amazon. Amazon is incorporated in the US, and we all know it's an online marketplace, an e-commerce platform where they sell products online. But they do have warehouses and godowns in several places in India. So here we can infer that Amazon has a place of business, both electronic and physical, because this purchasing, the customer base, the business activity that they do is through an e-commerce platform. But because they have warehouses in India, they also have a physical place of business. Now, whenever such transactions happen electronically, the Information Technology Act 2000 of India also becomes applicable to such transactions. And these companies, they need to ensure that the IT Act is also complied by with them. Here we have a comparative study between the 1956 Companies Act and the 2013 Act. There were a lot of changes between both. Starting with foreign company, the definition of foreign company in the 1956 Act did not include electronic mode. Back then, only having a physical presence in India was considered to be a place of business. However, in the Companies Act 2013, place of business can be electronic as well. Primarily because we now have moved to a very digital world. Foreign subsidiary was defined in the 1956 Act. That definition has been omitted in the 13 Act. In case of M&A transactions between a foreign company and an Indian company, in the 1956 Act, a foreign company was allowed to merge into an Indian company, but an Indian company was not allowed to merge into a foreign company. In the 2013 Act, vice versa was also allowed. So now a foreign company can come and merge into an Indian company, and an Indian company can merge into a foreign company. With regards to filings and submissions with the ROC, additional details have to be submitted in the 2013 Act. Like if the foreign company had a place of business on an earlier occasion in India, opening and closing of that place of business has to be notified. Details of that have to be given to ROC. There are certain declarations that have to be given by the director or company secretary of the foreign company. Now, these are declarations like declaration that the director is never convicted or was never debarred from carrying on any business in India or outside India. Certain declarations, like if they're not Indian nationals, if they don't have a PAN, a declaration in that regard that they don't have PAN, these are from a procedural aspect also. There are a lot of additional documents that have to be submitted in the 2013 Act. Next is with regards to registration of charges. Earlier, if the foreign company had created a charge on a property situated in India, that charge had to be registered. However, in the 2013 Act, a charge created on property situated in India or outside of India also has to be registered. Now, this particular amendment is not coming in directly into Chapter 22. This change happened in the Chapter 6, that is on charges. In that chapter, all charges created by an Indian company on properties situated in or outside India have to be registered. So we can say that for foreign companies, this amendment can be applied mutatis mutandis. Accounts.
Ma'am, can I ask? Yeah, regarding the property which are situated outside India and going to create the charge in India. So, is there any permission required from the foreign government, or suppose let's say particular land or property is based on leased given by the lease on the foreign government? So in that case, is any permission is required?
So outside of the Companies Act, sir, we are here primarily focusing on the
Okay,
Companies Act.
understood.
There
Yes,
are
yes.
RBI guidelines which the company
Yes.
has to follow. There are FEMA regulations which the company has to follow.
Yes, understood.
Law of that country where your property is situated, that of course you have to check. We can't comment.
Exactly.
Because
And I think Even in India also, you need permission from various authorities, if they have interest in the company for creating the chart. So I think the same position will be there. I think you need a
Because
permission.
it may considered as a current account transaction. So might be RBI permission is required from in India also.
No, there are two issues will be there. One will be what is the RBI regulation. Second will be, as Dipti puts it correctly, the regulation which will be applicable in that country. Now, for example, if the lease land charges are created, if that country says that you have to get the no objection certificate of the person who was given the lease, then naturally that has also to be complied with.
Yes, sir. Yes, sir.
So check the agreements actually. You have to check your agreements.
Yes, ma'am. Yes.
Because primarily we are talking on this Companies Act, and apart from that, foreign companies are also governed under the FEMA, under the foreign direct investment, under also the RBI regulations. So we need to look into those regulations and we need to comply with that.
Remittance to and fro from outside into India or from here to there are anyway governed by RBI guidelines. So those have to be complied with.
Yes, yes, understood. Thank you.
Next up is accounts of the foreign company. Earlier, only balance sheet and P&L were to be submitted with ROC. In the Companies Act 2013, there were additional documents which needed to be a part of the accounts of the foreign company. That is a statement of RPT, related party transactions, a statement of repatriation of profits, a statement of fund transfers. So these are some additional documents that have to be submitted along with the accounts of the foreign companies. Penalties on non-contravention on contravention of the provisions of the Act were lower in the 1956 Act. In the 2013 Act, the fines are higher.
Much higher.
Yeah, much higher, right? So they are without a cap actually.
Yeah.
If for any additional day of delay, there's no cap on it. Every day of delay, there's a fine which keeps on adding and adding till you comply. Next, let's see the sections of the chapter 22, how they become applicable to foreign companies. So chapter 22, that is for companies incorporated outside India. It is applicable to foreign companies only. To the definition that we saw before, only applicable to foreign companies, but not all sections in this chapter are applicable to all foreign companies. So section 380 to 386, 392 and 393, along with the rules made thereunder, these are applicable to every foreign company. However, all applications or all sections of this chapter, including the ones that is 387 to 391, these are applicable only to those foreign companies which have in which not less than 50% paid up capital is held by an Indian citizen, Indian companies or Indian body corporates, basically. This paid up capital can be equity, preference shares also. It can be fully paid up or partly paid up, but the condition is that at least 50% of the paid up capital in the foreign company should be held in India. If that happens, basically, if the foreign company is raising funds in India, every single section under this chapter become applicable to that company.
That means it will depend upon the activity the foreign company is actually doing it. If the foreign company is not raising the capital in India, then these sections will not be applicable to them.
Right.
So definitely much will depend upon the activity what they are doing.
Because these sections are more about prospectus and raising funds in India, about
go back one slide. Go back one slide. Shailesh boy, he is there. He was specifically asking what is the rule. Rule is mentioned here actually. The companies, register of the foreign company rules 2014.
You're on mute.
No, I was able to locate what I wanted. It is not the rules, but it's something else, which after Vrunda finishes, I will touch upon.
Okay.
And
sure.
I've requested Ashwini to join for that little piece. She will
Okay.
join around 12:30.
Okay.
We had
sure.
handled a good matter, both she and I had
Okay.
handled a good matter on foreign companies when about 3 years ago, 2-3 years.
We'll be benefited to have your personal
Yes,
experience.
it will be useful. So 12:30, she's joining us.
Okay, good.
Place of business in India. 381 is for accounts of foreign company. If that foreign company needs to make its accounts and submit to the ROC. Section 382 is for displaying the name of foreign company, similar to what we do in India. If there's a company, the name of the company, the registered office, and such details need to be displayed outside the office.
But the only thing
However,
is in the display,
place
they
of
not
business.
also mention the
Yeah.
origin of the country in where the incorporation of the
So
company. is
foreign
done.
companies, those details are different, but they also need to display the name of the foreign company outside their place of business
In India.
in India, right?
Yeah.
Section 384, provisions pertaining to debentures, annual returns, charges, books of accounts, the Section 71 and the Companies Act provisions, those become applicable to foreign companies also, mutatis mutandis, to the extent that, with certain changes, basically. Section 385.
Or instruction. The board of directors of the company is accustomed to act. So in relation to foreign company, so because its director is not defined in that company and who can be director, so any persons whose instruction direction the Indian company
Is accustomed to act.
accustomed to act. And here we can take another complication, the express and place of business, which we have taken earlier, but we skipped that.
Yes.
Includes share transfer or registration office.
Correct.
So it is share transfer or registration office. So registration office is included, but the share transfer is really word
We need some more clarity on what share transfer means.
because it says place of business includes a share transfer or registration office. So it can be, we can take that, Shailesh bhai, keep eye on what I'm talking. Includes share transfer or registration office. So we have to take an includes a share transfer or registration stock office or share transfer or registration office. So we can
Why do you catch Shailesh on this?
Hey, you are master blaster of drafting. I know that. So share transfer, we have to take that way. I'm taking Mr. Bala, right?
I think it is RTA, something like an RTA.
Yeah, correct.
So that's why we have to correct that way only. No, otherwise, if you take share transfer, then it doesn't have kind of per se meaning of share transfer.
No, RTA office they are talking.
RTA, they're talking about an RTA office.
Or registration. Now I'm telling you, see, I have learned such a thing for you, no? So something I'm telling. Share transfer or registration and then office. Office word common for both.
Yes, correct.
Okay. Yeah, please go ahead.
Next is section 392. It's for punishment for contravention of the provisions of this chapter. It defines the amount of penalties. Section 393 is failure to comply. What happens if the foreign company fails to comply with the provisions of this act? So what happens, that is given in that section.
Basically, the foreign company need to adhere all the company's law, right from maintaining the place of business, maintaining the books of accounts, appointment of the auditors, getting the auditing done, filing, etc. Everything is done. But only difference here is this particular foreign company management is actually looked after by centrally located registrar of companies at Delhi.
Yes.
Right.
Because in other places it is looked after by the respective registrar office in the various states, where it is actually done at the Delhi, who's centrally located, who's actually monitoring the thing. All the things is required to be filed. In fact, really speaking, the filing form of the financial statements are also different. And even annual return form is also different format, because we are talking about a SPRL format here, where they are talking about FC1, FC2, FC3 like that.
Yeah.
So that is the way they said, but the bottom line is the compliance under the Companies Act is required to be complied with. Yeah.
Now, these are the 5 provisions which get applicable when a foreign company is raising funds in India. So if not less than 50% paid up capital, that is at least 50% of the paid up capital of the foreign company is held in India by Indian citizens, Indian companies, Indian body corporates. These are the 5 sections that the foreign company needs to comply with. 387 is for dating of prospectus and the particulars which should be in the prospectus, details and annexures of the prospectus. 388 is an expert's consent which is required before the prospectus is issued. Section 389 is the procedure for registration of prospectus with the Indian authorities because that company is raising funds in India. Section 390 is regarding Indian depository receipts, the procedure, the eligibility criteria, all of that. And 391 is application of 34 to 36, section 34 to 36 of the Act and chapter 20. So this is 34 to 36 and 20 is of the Companies Act 2013. So this also becomes applicable mutatis mutandis to the foreign company.
Bala,
Yeah.
are you aware of instances where foreign companies have raised capital in India, or is it only that Indian depository receipts? I do not quickly recollect any foreign company raising capital in India. It vice versa is there. Indian companies raising capital abroad, but any company in India which has raised foreign money,
No.
or if or not, any foreign company has raised capital in India.
Yeah, it happens.
Any instance are we aware? At least I don't know.
Ashutosh, can you comment?
No, I don't think per se when raising a capital, it's permissible also under without proper ICDR, following ICDR regulations. So while it's an enabling provision, but I think without following Indian regulations, no one will be able to raise public in India.
Yeah.
Very similar, like we will not be able to raise public money anywhere outside India in any jurisdiction without complying with normal norms. So you're right, sir. But I've never seen such a pass. And exactly, you're correct that I don't think it is possible.
It is for
Ideas are
public.
there.
Sorry.
Indian depository receipts
Yeah.
are allowed, but that has to.
No, Indian depository
get to
receipts,
the
yes.
Commissions.
But Shailesh bhai,
Okay.
is raising finance from public not necessary. They have mentioned that if it is public, somewhere it is there, Brinda can point out.
Can be raised privately
It is
also.
an IDR, and if it is through private thing, a private placement or through kind of deposit, that they are covered. Otherwise, it is IDR only if from public.
Only idea, but can
Yeah.
they not just make an issue of shares and offer it to Indians and Indians subscribe to it? And of course, you follow all SEBI rules for this, make prospectus and all.
No.
Are there instances? I do not know any instance.
It's 1-to-1 if foreign Indian investor is there and 1-to-1 they take 1 or 2. That happens. That is also raising finance, but not from public. So
Not
if
from-
public, then all this provision and idea. Both will.
Right.
Oh, so let's look at a few sections which are applicable to all foreign companies. Section 380 is for documents which are to be submitted with the ROC when the foreign company establishes a place of business in India. So there's a form FC1 which has to be filed by the foreign company within 30 days of establishment of place. A lot of documents that the foreign company needs to submit to ROC Delhi along with this form FC1. That is a certified copy of that foreign company's memorandum of association, charter or constitutional documents, or whatever constitutional document it has in the country of its origin. The address of that, the principal address, registered address of that foreign company, the address of a place of business which it has in India, details of directors, company secretary by whatever name called of the foreign company. The details which are given in the rules, what all details need to be given. Details of authorized persons in India. So that foreign company would have an authorized person in India who would look after the business. details of that person also have to be submitted, and a declaration from the directors and the authorized persons that they were never convicted or debarred from incorporating a company or managing a company in India or abroad. So this, like we saw earlier, a comparison between 1956 and 13 Act. This was the difference. This was an additional requirement in the 13 Act, a declaration to be given by the directors and authorized persons. Separately, there's a form FC2, which the foreign company.
So wait, sorry, Brinda.
Yes,
So
ma'am.
it says if the person is not authorized to set up the company in its own country or any other country, can't set up in India also.
I would say the better word for it would be debarred. So by law, if that person in that company is prohibited, then it should not be doing that in India either.
Yeah, so he will be ineligible.
Yeah. So all of these details which the foreign company filed in form FC1, if there's any change in these details, these alterations can be filed in form FC2 within 30 days of the alteration. Now we saw earlier that the foreign company needs to give certified documents. Like we saw, ma'am, in section 386 also, in the interpretations, this word certified is explained better there. So these documents are certified. The certification can be done by an official of the government of the foreign company in which the original is situated, notary public of that country, or the official of the company. So these three people, either of these three people, certify that document. However, there's further authentication required in certain cases. For example, if that foreign company is a member of the Commonwealth, no further authentication is required.
Oh,
If that foreign company is not a member of the Commonwealth, that document is to be authenticated by the diplomatic or a consular officer. Who that officer can be is defined in their own rules and in their separate act. Now, if that company is not a member of the Commonwealth, but is a part of the Hague Convention, that document needs to be apostilled. So that is what we mean by certified.
what is apostille? What does it mean?
So apostille, this happens at the embassy level. Hague Convention is basically some 100 states have come together to protect the rights of children who have been abducted from their home country. So it enables those children to get back into their home country. And to keep a track on that, this is called apostille. This apostille is a certification done at the embassy level.
Okay, thank you.
Like a notary public and other things.
Like a notary public, yeah.
The embassy
Yeah.
has actually named the people who can actually apostille a document with a reference to the original documents. Because in most of the countries it is happening. Many documents which is coming from UK, it is normally get apostilled and it is given to the other countries. Because when I was working in African countries, many documents we were getting, because part of the people who are situated in UK, we were getting the documents apostilled from there.
Brinda, there is a clarification added by participant that along with FC1, if your documents are not in English language, then official translation.
Right.
Okay. Thanks for clarification.
Thank you.
Hello, may I come in, madam?
Yeah.
Hello. Yeah, may I come in?
Yes.
Yes, please.
This is Rishikesh here. Madam, what do you exactly mean by official of the company? Is there any list of officials of the company which is there in the?
So that happens at the foreign company level. Like a foreign company could have multiple level of hierarchies, and a certain person could be authorized to do some activity or some transaction. Like even in India, we can the board can delegate its powers to the official. So that official of the company would be approved by the board of that foreign company. So that person can be said to be an official of the company.
So,
Authorized representative, actually.
Yes.
The board of the foreign company has to appoint an authorized representative, and the name of that authorized representative and number of shares which has to be subscribed has to be particularly mentioned in that board resolution of foreign company.
right. Okay, ma'am. Thank you so much.
So foreign companies under section 381 have to maintain their books of accounts. similar to what Indian companies have to do. And these accounts have to be submitted with ROC Delhi within 6 months from the closure of the financial year. An annual filing that we need to do, it includes balance sheets, P&L account, consolidated financials of parent company if the financials are consolidated, statement of RPTs, statement of repatriation of profits, statement of transfer of funds. The three things which we saw were added in the 13 Act. List of all places of business in India that the foreign company has set up. That there's a separate form FC3 for the list of all places of business in India. So these need to be submitted with the accounts of the foreign company annually within 6 months from the close of the financial year. Furthermore, these accounts have to be audited by a chartered accountant, a practicing chartered accountant in India. The name of the foreign company.
Brinda, just to add, I think if the accounts are not filed in 6 months, like our Indian company, you get extension also on application. For
Yeah, there can be an extension of up to 3 months, similar to what we have for Indian companies.
Yeah, please carry on.
The name of the foreign company has to be displayed outside the place of business and on other documents. The name of foreign company, the country of its incorporation, and if that company has a limited liability of members, then those details have to be clearly displayed outside every business office and a place of business in India on the letterheads, official publications, advertisements, notices. These details have to be conspicuously displayed. So if the ROC or any authority or any person in India wants to service some document on the foreign company, if we send these documents by post or any electronic mode to the authorized person at the place of business, the details of which the foreign company had submitted in FC1, it is deemed to be sufficiently served to the foreign company. These are the 6 certain provisions which are applicable to foreign companies, just as they are applicable to Indian companies, but mutatis mutandis. Section 71, debentures, provisions of issuance of debentures have to be complied with if foreign companies do these activities, but it's all mutatis mutandis. Section 92, filing annual return. For foreign companies, there's a separate form FC4, which has to be filed within 60 days of closure of financial year. Section 128, maintenance of books and records. Foreign company has to maintain books and records. Section 135, CSR provisions. Chapter 6 on charges and chapter 14 on inspection, inquiry and investigation. All of these sections become applicable to all foreign companies, mutatis mutandis to an Indian company.
The attention to CSR is very crucial.
Yes. So if in the financials, if the financials of the Indian, if the place of business, like they have to prepare their accounts, if they hit that criteria of CSR under 135, they need to do the contribution as well.
That is applicable.
Average.
Definitely CSR
Yes.
activities are applicable. A lot of foreign companies are already doing it.
Bala and Brunda,
Yes.
both Ashwini and I had an opportunity to discuss CSR with foreign companies, and we had a very long discussion and did some research also on that. I have asked Ashwini to join the discussion at 12:30. She's on leave, but she has agreed to join at 12:30. Is it possible for you at that point of time to have rule 2H of the CSR rules on the screen? Would it be possible? Bala, with your permission, it may be a little, it will be a little diversion, but it will be interesting.
Sure. Why not?
2H, not just now, after Ashwini joins. 2H, 2 brackets H of the CSR rules, of the CSR rules. Okay. If that can be put on the screen, discussion will be enabled.
Sure.
Okay, thank you.
Section 385 is for registration fees. Now, all of these documents have to be submitted only to ROC New Delhi by the foreign company on payment of such fees which are prescribed in the rules. Now, what if the foreign company does not comply with these sections? So if the foreign company has entered into any contract or a dealing or a transaction, that contract is not invalidated. There is no effect of non-compliance on the foreign company's liability to be sued. So even if the foreign company does not comply, one can still sue that foreign company. However, the foreign company will no longer be able to initiate legal proceedings. So there's a case law on this in the case of Dabur Nepal.
Brinda, 1 minute.
Yes, ma'am.
Brinda, hand is raised. I can't see his name. So the person who raised the hand, please. Yeah, please. You have a point? Someone has raised the hand, but it's giving mobile number name only. Okay, go ahead.
There's a case law on the foreign companies' rights to initiate.
कुछ रिजेक्ट हुआ था, कुछ लॉट 2 लॉट में माल था, क्या है?
On the foreign company's right to initiate legal proceedings in India if it is in non-compliance with the provisions of this chapter. So in the case of Dabur Nepal versus Woodward Trade Links, where Dabur Nepal was the petitioner and Woodward Trade Links was a respondent, Woodward Trade Links had prayed that the suit instituted by Dabur Nepal be disregarded because Dabur Nepal was in non-compliance with the provisions of section 380 and 381 of the 2013 Act. That is submission of documents to ROC and filing of accounts. Those two sections which in the 56 Act were 592 to 594. Dabur Nepal had not complied with these two sections. So as per Woodward Trade Links, they could not initiate any legal proceedings in India. The facts established in this case were that first and foremost, the petitioner company was incorporated outside India. That is, Dabur Nepal was incorporated outside India, and it had a place of business in India for two reasons. One, it had godowns and warehouses in India from where it was carrying on business. Secondly, it was a subsidiary of an Indian company, Dabur India Limited, and all business of Dabur Nepal was being handled by Dabur India Limited from its Delhi office. So it had a place of business in India, and it was established that Dabur Nepal had not complied with the provisions of 592 to 594 of the 1956 Act, that is 380 and 381 of 2013 Act. It was ruled in this case that the petition filed by Dabur Nepal was not maintainable because one, it was a foreign company with a place of business in India, and foreign companies which are not complying with the provisions of section 592 to 594, that is the 1956 Act, in the 380-381 cannot institute any legal proceedings. So that suit petition was not maintainable.
Brinda?
Yes, ma'am.
So it is there mentioned that since petitioner is a subsidiary of Dabur India, and its affairs are and it is carrying out business activity in India, so that's why it is a foreign company, right?
Yes. So it was established that Dabur Nepal has a place of business in India because the Indian subsidiary was handling the business of Dabur Nepal from their Delhi office. So it was jointly, subsidiary bhi tha and affairs were also being handled. Both those conditions were being fulfilled. May I proceed?
Yeah.
Next, let's have a look at the provisions for merger with an Indian company, merger of a foreign company with an Indian company. Pursuant to Section 234 of the Companies Act, foreign company can merge with an Indian company or vice versa, but prior approval of RBI has to be taken. And certain provisions of FEMA Act has also have to be complied with, like sectoral caps, if any, on that particular business, those the company has to take care of. Now, foreign company can raise funds in India through two modes. One, they can do it privately through Indian investors or banks and financial institutions, or they can do it publicly by issuing prospectus and Indian depository receipts. When raising funds from public by issue of prospectus, so foreign companies raising funds in India have to anyway comply with the requirements that India has. But for foreign companies, a certain additional details or annexures have to be submitted, such as the contents of the prospectus and the annexures which should form part of the prospectus. In the prospectus issued by a foreign company, there have to be given the instrument defining the constitution of foreign company. So the charter documents of the foreign company, those have to be, those details have to be furnished. Provisions under which the foreign company is incorporated, the laws of their land, address in India where we can inspect these documents, date and country of incorporation has to be mentioned, and address of the place of business in India also has to be mentioned. Certain annexures additionally have to be submitted, that is a consent from an expert to issue prospectus. The contracts of appointment of whole-time director or CFO of the foreign company, material contracts which the foreign company has entered into in last 2 years, but these are not in ordinary course of business. The underwriting agreement that the foreign company had entered into, and a copy of the power of attorney if this prospectus is being signed by an authorized person instead of the director of the company, of the foreign company. So provisions of section 34 to 36, similar to, the ICDR regulations and other applicable provisions that Indian companies have to follow when raising funds in India, a foreign company also needs to follow them mutatis mutandis. Now, procedure to issue IDRs is a vast topic, maybe a topic for another day, but here I have given the procedure to issue IDRs in very brief. The foreign company has to file an application along with a draft prospectus and a due diligence report with SEBI. SEBI would then provide their comments or requests for any changes to be done in the prospectus. And then the foreign company will have to refile it, make those changes. And post that, SEBI will give their in principle approval. This, after approval is received from SEBI, the final prospectus has to be filed with SEBI and ROC. The foreign company will have to appoint an overseas custodian bank because the underlying shares are of a foreign company, a domestic depository, a merchant banker, and an underwriter. These shares which will be issued, shares of the foreign company, will have to be delivered to the overseas custodian bank that the company would have appointed. And in principle, approval has to be taken from the stock exchanges before we can initiate, trading in the markets. In addition to Chapter 22 of Companies Act, rules of this chapter have to be followed. SEBI ICDR regulations, issue of capital and disclosure requirements have to be complied with. Directions, if any, issued by the RBI also have to be complied with, and FEMA regulations have to be complied with. So there are certain compliances under FEMA. Under FEMA, foreign company as such is not defined, but it does make certain provisions applicable to companies which have, to foreign companies which have businesses in India through a liaison office or a branch office or a project office. So these offices need to comply with certain, requirements of FEMA, like the liaison office, branch office, and project office have to submit a report in Annexure 3 to the DGP within 5 days of establishment of its place of business in India. Now liaison office is does not carry on any business, so only the branch office, the branch office and the liaison office have to file annual activity certificate in Annexure 4 with the AD Bank and the Director General of Income Tax within 6 months from the end of financial year every year.
Whenever it comes to the merger,
Yes.
and the sectoral gap is actually beyond the limit, then again the necessary approval from the concerned ministry will be called for.
Right.
Because when we talk about the merger, there are various sectoral gaps which are applicable for the specified classes of companies. In
Yeah,
such cases, the respective specific ministry's approval will also be called for.
Vrunda,
Yes, sir.
Vrunda, I think Ashwini has joined in.
Okay.
How many slides more do you have?
So almost done.
Then finish your slides and then we will go into that 2H.
Sure, sir. Definitely.
Ashwini, you're there, aren't you?
Sir, I'm there.
Okay, great. All right. Okay.
So if the foreign company does not is in contravention of these requirements, if these sections, there are fines and penalties put in place. The foreign company is fined, will be fined not less than 1 lakh, but up to 3 lakhs with rupees 50,000 per day for the continued contravention. This
Without any
continued
gap.
contravention is not capped.
Yeah.
Yeah.
So till such time it is rectified, it will incur.
Yes, so there's a huge penalty for every day of contravention, and the company, it will keep on adding on till it complies. So it has, the provision has been made stricter. The officer in default of the foreign company will be fined not less than 25,000, which may extend up to 5 lakhs and or imprisonment of up to 6 months. So it can either be a fine or imprisonment or both, depending on case to case basis.
So this can go for a condonation in case, if anybody has defaulted.
Yes.
Right, Mr. Bala? Because
Yeah.
it says and or.
You can make an application for the condonation, but how far and what amount of the fees it will be condoned will be left to the regulators. Because I happen to be associated to one of the foreign companies where I was working some time back. They somehow did not file the annual return for a particular year. When they wanted to file the annual return for the next year, this came to the light, and ultimately the huge penalty was to be paid. Because we tried to get the condonation of the delay, as you rightly said, etc., and other thing and all. We said there is no justifiable reason when you are having a people around, etc., and other things and all this thing. You have to go by the fee. That is what they said actually. So ultimately, we have to pay a huge fees.
So if you have any penalty with a word or, so this can go for a condonation, right?
Yeah.
So this offense is condonable.
Correct.
Vrinda, continue. Oh, acha.
Oh, yeah.
Actually, Mr. Bala, I have a question, Salish bhai. Like we have a company like Wipro and all, they are listed out of country, like New York Stock Exchange and all. I don't think so. We have any company which is listed in our exchanges, which are of foreign countries. And does it mean that Wipro has listed its share in a New York Stock Exchange, so they have raised some capital from those countries, or it is the Indian shares which are also listed on those exchanges?
No, most of these companies have got foreign shareholders.
Yeah,
And
they are having a foreign shareholder. They would have definitely raised what you call ADR and GDR.
Okay.
No, and then in that case, you see, there are certain issues which are very clear that this can be done only in India, that it cannot be issued outside of India. But if you want to issue, then you have got a number of filings which you have to do with the stock exchanges or the securities regulator of USA. So you can have this. But my question was on similar things, I had a slight doubt in my mind. These companies, especially the IT companies, have got so many subsidiaries outside India, running into hundreds. Are all these companies foreign companies? They are registered there, but they are fully owned by the Indian parent.
So that's the Pandora box of, what place of business means. There are foreign companies who have set up, say, wholly owned subsidiaries in India, but the contention is whether they have a place of business. Can we say that a foreign company having shares in India is sufficient to establish that place of business?
No,
Or
foreign company.
just an investor?
It's not the Indian company is the investor there. See, the Indian company holds 100% of the equity of that foreign small company. Especially all these IT companies, they have established so many companies in small countries all over the world. It is the Indian company who has invested there. And at most, it may be getting dividend, possibly, if at all.
Vrinda, what is
Those
Dabur?
foreign companies.
In
Ma'am, in the-
Dabur case, what was the case? The subsidiary was overseas or holding company overseas?
Subsidiary was overseas. Dabur Nepal is an overseas company. The holding company was an Indian company, Dabur India Limited.
Yes.
Shailesh Bhai, Dabur India, what's it just now carried out?
Yeah, but then in that case, that Dabur Nepal, was it a foreign company as per the act?
Yes.
Yeah,
Yes.
it is.
That was the case we discussed, no?
The
Yeah.
case was it is a foreign company.
And
Therefore,
my connection stopped and there are so many questions. This Dabur is a right case law CS selected. In chat box, this holding subsidiary thing is there. That time we will discuss many things. That is the thing I have taken last. So now we will take your CSR question and then chat box. In chat box, this holding subsidiary continuous question is there.
Okay,
So
shall we
case
take
law
this
is a
question?
landmark case. Yes. This case law is a landmark case
Yeah.
in which this Companies Act 2013 amended provision have come into effect regarding
Right,
foreign.
right. Otherwise, the old one is there. So I told her to remove
Yeah.
that earlier old one also 1956 years put, which you
Yeah,
heard.
The Willis Group
was Willis.
case law,
It was
ma'am,
Willis India.
that you were talking about. We were
Yeah,
planning to
Willis
use
India.
that earlier, but that was in the old law.
So
Yes.
then I said that remove because it will create lot of confusion. And then
Right.
already topic is confused, we will confuse more if you write that.
But I think sir has a very valid point that if there are subsidiaries abroad, of any Indian companies, whether they will be considered as foreign companies. I think you interpreted its definition, sir. There is a scope that it will come under the ambit.
अरे ये डाबर में वही किया ना इन लोग ने.
Right.
But it has to have place of business in India.
Ah,
Then
place
it
of
has-
business.
Place of business is there, no? It's an Indian company.
So then it's a foreign.
Yeah.
हाँ तो वही ना हो गया तो all subsidiary become foreign company. Same way
Yes.
overseas holding company become foreign company.
No, but then it could have been very easily put into the definition of
अरे
foreign
हम घुस
company.
गए holding subsidiary. Wait, there are chat box same questions in different way.
No, so
let-
in the same case, for example, Wipro has a subsidiary in US, which is just carrying on business in US. That subsidiary has no connect place of business in India. That
Correct.
subsidiary.
Yes.
Then it's not a foreign company.
Ah, it has no place of
is
business.
important.
It is
Yes.
there. It is doing
Correct.
business here. At most, it may be sending dividends to the Indian company. That's all.
That's also. Then I
Yes.
don't think it's a foreign company.
So there has to
And
be a
this-
connection between the place and business. actually.
1 minute, I have to stop.
No,
Just
Dipti ma'am,
CSR at present, Shailesh Bhai wanted, and then we are taking this holding subsidiary. There are
Okay.
different ways. Only
Okay, fine.
pure investment, business, franchising, many things are there in chat box also.
Can this be expanded a little bit? What you have put on the screen, it's a little difficult to read. Is it possible to make it bigger? If
Sure,
not-
sir, I'll try.
If not, chodo. Then we'll do with this. Ashwini, you're there?
No, sir, I'm not able to zoom it.
Okay, that's okay. Ashwini?
Yes, sir. Yes, sir.
Yeah. Well, Ashwini and I in Mehta and Mehta had a very nice opportunity to go into this part of foreign company in great depth. The issue then was that there, Ashwini, correct me wherever I'm wrong. Please interrupt because my recollection
Yes.
is not that sharp as yours.
Yes, yes, sir.
The situation there was that an Indian company had set up a wholly owned subsidiary abroad. That wholly owned subsidiary was set up as a company and it was not a branch. The A talks about, little one talks about branch. It was not a branch, it was a wholly owned subsidiary. That wholly owned subsidiary remitted dividends, paid dividends into the principal company in India. The question was that H says that net profit for the purpose of CSR shall not include the following, namely, 1, any profit arising from any overseas branch or branches of the company, whether operated as a separate company or otherwise. Now, when we talk about branch or branches of the company, we understand that a profit generated there, since it's a branch, there is no separate corporate entity, the thing would straight away come into the books of the Indian company. Of course, the Indian company would have to keep separate accounts, separate distinct accounts to show that this is from the foreign branch, so that there is distinction and no intermingling, total intermingling, so that you cannot identify it. But if the company is established as that thing is established as a separate company and it remits dividend, then does it fall under any profit arising from any overseas branch or branches of the company operating as a separate company? And then also that word or otherwise is there. Any profit arising from a separate company. Any profit arising from a branch operated as a separate company. Because this becomes very important. The amount of dividend which was paid was quite sizable. Is it liable for CSR contribution or not? Now, we argued that in the case of an overseas branch or branches, there's no question that whatever profit is there from there is to be excluded. But in the case of a company, the dividend is not really profit arising from that company. It is remittance of some of the profits. It can even be remittance of previous year's profits. So would dividend sent fall under profit arising from the separate company? Then in addition are the words or otherwise. Now what is or otherwise is not clear. And in B and in little 2, you have got something separate for dividend. In the case of India, but little 2 applies to Indian companies. Okay, but there it is clearly mentioned dividend. There it is not profit. Any dividend received from other companies in India, which are covered under and complying with 135. Little 1 does not have the word dividend. Little 1 talks about profit from a separate company. Whether dividend received from that foreign company is profit received. And lastly, what is or otherwise. Ashwini, would you like to add something?
So basically 1 is not talking about dividend and 2 is not talking about profit. That was the
Correct.
issue. Yeah.
Correct.
So how do we calculate, how do we tell them, because they used to receive a huge amount of dividend from the foreign company.
Yes.
And there was always this thing whether because of that dividend, they were just crossing the 5 CR every time. So whether
Correct.
they are liable for CSR was the question. So it was just like whether they are in or out for the CSR.
We did a lot of research on this, and the person with whom we were talking, the company, Indian company, wanted to be very compliant, and he was not bothered about the 2%. Even if we add it and we get into CSR requirements, doesn't matter, he said, but he wants to be on the proper side of law. So we did a lot of research, and okay, open for discussion, but then there are some guidelines. We found out something, but it's open for discussion.
May I say something, Deepti?
Yeah, please.
See, if you read it, that subsection 1, the I1, HI, any profit arising from any overseas branch or branches. So basically it should come from the branch. Now, branch could take a form of a company or otherwise, but I don't understand branch can take a form of a company.
Yes,
or
that's
otherwise
right.
could be possible, like if you have a, let's say, proprietary company. So then that profit automatically, being a proprietary company, will get incorporated in the profit and loss of the holding company. So it's nothing but the branch. In that case, that profit needs to be excluded for working out CSR.
If it's a branch and not a separate corporate entity.
So my understanding is that first of all, it has to be a branch, and branch should have any form. Now, if you form a company, it is not a branch. Like you have incorporated, let's say, private limited company or public limited company in Mauritius, Europe or USA or Singapore. That's not a branch. It's a separate entity. So whatever profit they make and then they declare a dividend will not be a profit from the branch. Basically, what happens, like if you are into partnership, for example, in the Mauritius or let's say in the UK, so that profit will come in your profit and loss, whatever is the profit of that partnership and your share from that. So that could be treated as it is of a branch, and because it is overseas, you don't pay CSR on that. I mean, that is how I can interpret.
But then how would the profits of a foreign company? See, that dividend from a foreign company is out of profits which they have made there. And the basic concept of CSR contribution is for profits earned in India. And hence that first part it is excluded. Now you have received dividends from a foreign company out of its profits earned there. So obviously it is foreign income. And
No,
therefore, why should it be subject to 2% in India?
No, are we now referring to clause 2? Any
No,
dividend received?
No.
We are still in clause 1.
Clause 1.
So it clearly talks about profit arising from any overseas branch or branches of the company.
Yes.
Whether operated.
When it says profit arising from a separate company, let me read it like this. Any profit arising from a separate company is dividend that is declared by that company, not a profit resulting to the Indian company?
Because dividend is not a profit from the foreign company, it's a distribution of the profit. So,
but where is it going? When you receive it, it's going into your P&L account? In the Indian companies?
It will not. It will come into your P&L only when dividend is declared.
No. It is declared and received by it is declared by the foreign company. It is received in India. Then it goes into the Indian company's P&L account.
So if I have to take this,
okay.
Technically, if it's a branch, so if it's a branch office in India, first of all, if it's a branch, it gets directly added to your P&L. If it's a purely branch, the confusion is where the word uses company. Some jurisdictions are there, they don't have a concept of opening an office or a company. Like Mauritius, we are know that case a separate office can be opened. In Dubai, you can open a separate office. But some companies don't allow you to just open office of an offshore jurisdiction. You need to open some company or something like that. So Indian perspective, you consider it as a branch, but in that jurisdiction, it may be a separate company. Till the time your balance sheet gets directly added to your profits, 0.1 gets triggered and you will have to do CSR. My understanding is
that means if
correct, that is where Ashutosh, I have interpreted in this way that if form of the foreign entity, if it is a proprietary or partnership, automatically it will enter your P&L.
Yes.
So has to be liable for CSR. Other than that, no. That is my interpretation.
Yeah. So because second part, so if the profits does not get directly added to my accounts, then the second leg comes. Okay, profit is first booked there in offshore jurisdiction. Maybe it's a company, and then it comes in form of dividend to us. That second point is covered.
So would I be right in saying that the dividend that is received by the Indian company, it is declared by the foreign company, transmitted to India, received by India during the accounting year, then, and it therefore is credited to my Indian profit and loss account?
No. Mr. Raja, let us not mix up 1 and 2. First one,
I'm not mixing. I'm not mixing 1 and 2.
Correct. He's coming to second point.
Let us discuss 2 separately. Now, 2, what it says that if I have a subsidiary in India, that also is liable under 135 for CSR, then any dividend I am receiving from that my subsidiary, I should exclude.
Yeah, but it just excludes Indian entity, doesn't exclude the foreign company.
That is to be excluded if it is in India. My company is abroad. It's in foreign show. That is the country.
So we are not in little 2 at all. We are not
in little 2. We are not in little 2.
So I mean, my interpretation as far as we are in 1 is, if your foreign profit enters your P&L, that can happen only if either it is a proprietary or it is a partnership or it is a joint venture. Because assuming that you have a company in India and you have another proprietary company in India.
Joint venture, no, not joint venture. If joint venture is
Not
set up
joint venture, it's a proprietary company.
proprietary or it's a branch.
Whatever. So in automatically it will be a part of your P&L.
Yes.
If it is partnership, then your share of profit also will enter your P&L.
Yes, correct.
Exactly. That is where it will be liable for CSR.
It will
But
not be
as-
liable. It will not be liable. Please. If it's a
sorry,
foreign
excludes. Yeah. So
excludes. Yeah, it will not be liable. But if it is a company, then if the foreign entity is a company and not a
Hello?
branch, standalone branch, then
There is also a guidance given by Institute of Chartered Accountants on this, wherein they have said in the little one that any profit arising will include any dividend.
similarly,
Okay.
there is an advisory also from Deloitte on this, which also is on the same lines, that it is to be treated as profit arising from the overseas, from that overseas entity, that it will
Okay.
fall under one.
okay, okay. So that means dividend to the extent it is declared and received by you, or not received,
Yes.
because your accounts will be on accrual basis.
No, I'm saying received. Let's not get into that accrual and not accrual.
Fine.
Let's say the money, it is declared by the foreign company, received and taken into your books. But it is dividend. It is not profit. Okay?
No, correct. But dividend always gets declared out of profit. So that part, even if it is taking a form of dividend, we should exclude from CSR calculation. That means.
This was our interpretation. It is supported by the clarification which Ashwini referred to just now. It is supported by what Deloitte has put out in one of its newsletters or something like that. Both of us did a lot of research. Ashwini did a lot of work on this.
Yeah, because what it looks like that if you have earned profit out of your activities in India or based in India, of that profits, 2% you should spend on CSR. The overall mechanism of CSR. looks like.
Correct.
So that's the reason that if foreign company has a branch in India, which also has to prepare a separate P&L file with ROC, they also need to spend 2% of their profit on CSR. So on that chronology, if we apply that logic, so Indian company earning from abroad by way of a branch or company, that needs to be excluded. That need not be considered for calculating 2% for CSR.
That is what we advised. But as
So that logic,
Dipti says,
it looks absolute logical.
yeah, but as Dipti says that I'm good at what using words here and there. It would have been nice if the legislature had put the words dividend into little one.
So idly point to, if it had been said any dividend received from other companies in India or
abroad,
then it was quite clear. It just stops at in India.
Yeah, it would have been very clear. Or even if it had taken any profit arising from any overseas branch or branches of the company, whether of any profit or dividend, there also you could have taken. But somewhere this great clarity should have been there. Otherwise, you have to go by interpretations, and this is what we felt.
I think it is as per what Nikhil said, it is profit derived from the operations and activities in India will be subject to CSR, that kind of.
Only that will be subject to CSR, and profit arising abroad will not be subject to a CSR.
Very good discussion. Can we go now to chat box? Thank you, Ashwini.
Thank you, Ashwini, for joining even when you were on leave. Thank you.
Brinda, we can now we can take a chat box questions. And the first question was conduct a business through subsidiary company can be included in any other manner. Brinda, can you bring on the screen the definition, because this will continuously now talk on definition. That conduct a business and all that, no? Here our holding subsidiary thing is coming into picture. We have mentioned any other manner, no? So foreign company is a holding company and it has set up a subsidiary. And the question is, and they are doing the business, whether then holding company is a foreign company or not. And that can become as included in any other manner. Question open to panel.
If I have to take start this because it's directly implies to me, I would say I would take a view that if I see the FDI regulations where technically the RBI and FEMA comes in place, but FDI consolidated policy clearly mentions that while wholly owned subsidiary investment in India, there are separate regulations, PIS route or FDI route. But if there are provisions relating to branch office, place of business in India, you don't follow the FDI regulations, you separately follow the branch and office and a place of business regulation, which has been established in India. So they have, RBI has bifurcated it into two. So if we take that analogy, here also we can take the analogy that investments in India, Indian entity is doing business in India, foreign entity is not doing it. It's Indian business. And the concept of regulator is ideally what we are saying, if foreign company is doing in India, anything else, you have an authorized person first. So authorized person is, we want to know who the person in India which we can catch hold of. We want to charge you for what business you are doing it in India. We want you to register in India because somewhere you're doing businesses in India and you're not directly registered. So indirectly you give us all this information. If you have a subsidiary in India, which is incorporated in India, you're paying CSR, registration, directors, responsibility, Companies Act, then I don't think we should link that to a place of business in India. But for example, in same case, we have a growing and grow India, for example. So if growing separately does anything else, which is not done by Grow India, again does a separate business in India, then it should get triggered, but it's only doing it through its subsidiary. It doesn't have any revenue stream or business or directly doing in India. My understanding, it should not be applicable. Per se, if you see the forms also which we filed with Delhi office, that FC1 or whatever that refers to, the form, if I just happen to see it and even the instructions behind that FC1 form, it says about you tell which place your business is, who's the authorized person is, and also provide if you have any other field for any other subsidiary associate if you have. So that field also tells you okay, your place of business is different and your subsidiary is different. So merging that two, my interpretation is that wholly owned subsidiary should not be up, but open to views and ideas.
Silpi, your view?
So I would, I'm recollecting here, one amendment, which was proposed in Companies Amendment Bill 2016. So, they proposed the amendment to Section 379, which states, and they proposed like foreign companies having any incidental transactions through electronic mode or any other mode to be exempted from registering and compliance regime under the Act. But I think this amendment has not brought yet by the MCA. We have not found any circular in public domain. So I think any incidental transactions, I think if any company is carrying on any incidental transactions like R&D or something like that, which doesn't generate any business or revenue, I think it won't be covered under the definition. But there is a lot of scope of improvement in the definition until and unless MCA clarify, this is a big Pandora box to resolve actually.
Mr. Bala, your view?
Yeah, definitely, because the question is not only a place of business, but doing a business. Okay, because as Ashutosh puts it, the holding company is not doing a business here. Although you may call it a place of business, but the condition, both the condition has to be fulfilled, and that is not getting fulfilled, so it will not.
But if we see Dabur India, their holding company is located in India, subsidiary in Nepal, and they made that foreign company. So I'll put it other way. Holding company overseas, subsidiary in India, then it should not be applicable.
So, ma'am, in case of Dabur Nepal had godowns and warehouses also in India.
that's
And
important.
yeah, so they also said that Dabur India manages the business of Dabur Nepal from Delhi office. So there were two criteria there. One was the subsidiary and that subsidiary handling the business.
Yeah.
So, ma'am, I'll give you an example that in various financial services company, for example, if you're doing PMS in India or even PMS in India, or now you want to do also offer, for example, Singapore related investments to Indian investors, right? Now, if you're offering Singapore related investments and you incorporate a subsidiary in Singapore, for example, because if you're offering any Singapore related securities to Indian public, you need to do us through a broker dealer license in Singapore, right? So what I do, I incorporate all of financial institutions have that, incorporate a subsidiary in Singapore, register there and offer through that securities. I have 5 or 6 people in Singapore. But what happens, my client in India gets enrolled at Singapore entity first, signs all forms of Singapore entity that he does KYC of Singapore entity. Then technically that Singapore entity will be deemed to doing business in India. First of all, it is you are holding more than 50% in that company through a subsidiary route. That company is also doing business in India because it's onboarding Indian clients. In that case, foreign company provisions will get triggered.
Okay. Okay. So we are telling that holding subsidiary, if either holding or subsidiary, anything located out of India, though act is silent, since this Dabur case, if that foreign company also has parallel business activity, then it will be foreign company, otherwise not. This Indian company will not be counted as agent or any other manner. And that was the question. If they conduct the business through subsidiary company, can be included in any other manner. They set up a subsidiary is agent. They sell, pay royalty to that other company. In that case,
that answer I don't have, ma'am. So, for example, even if a holdco company which is based in outside India charges any royalty to Indian entity, whether they're charging the royalty to Indian entity will consider as business in India, it's a matter of interpretation.
Well, why it should not be according to me?
So what I think
Royalty.
Yeah, please, Shilpi.
What I think is that, there has to be clarification from the MC itself that what do you mean by the incidental transactions, which will be covered under this ambit or not. So I think
And not only incidental, that amendment has not come into picture on
yes, this has not come actually.
And not only that, they have not mentioned that piecemeal transaction. So once it should be regular activity. Even 1 or 2 transaction happen or 3-4 transaction, then also it is attracting. This definition is covering business. Now then you have to fight it out. No, this is business is when I do repeated transaction, then I am intending through business. It's not 1 or 2, 3. Then they will say you are doing seed marketing. Because marketing and research is also covered. So it's a very Pandora box as on today. That whether my simple 2-3 piecemeal transaction happen will be a business or not. Business activity. Because it can be or it cannot be. Both way it can be. So it will be better.
It can be a mere incidental presence in India. There is no intention of the company to set up any business or conduct any business operations in India. We have to see that.
It will go on a factual then litigation that no, I had a market research and you have done market research. This was seed marketing and that's why this transaction crystallized. So it's a very ticklish issue. And again, if it is a subsidiary and they are setting up as an agent and giving, and suppose this subsidiary company provide after sales service of all the goods supplied in India, then it is very common.
Right.
So all this is there, actually it's not clear. And if we take Dabur case, so whether they have separate activity, as Brinda was telling that they are telling that they have by itself a business activity separately, then not only through subsidiary, then it will be. So let's at present take Dabur case, and if in addition to subsidiary you have additional activity, we should consider, otherwise not holding subsidiary either of it in India. Let's take that way.
Like one example I would like to share, this airline booking agents, the company is incorporated.
Yeah, that decided case.
Correct.
They have connection with all the airlines all over India. So what is the position of that company then? So it's all, I think the clarification has to be come in the definition itself. There is a lot of scope of improvement in that.
But I'll put that way again, like they are knowing that there are so many holding subsidiary and consolidated account and all that MCA is receiving. But never MCA has issued so-called notice to any holding or subsidiary or kind of thing for not getting FCR, right?
Yeah.
In that case, that means they have deemed to have accepted our interpretation, right? Because they are getting all the information. Otherwise, they should have up till now.
Regulator do not have the time. That is why they have not come back. So
I agree.
you can presume things for this time.
It's like application of mind. If any
Yes.
regulator
Nityavan, if you point out to ministry, they'll certainly prosecute or they will investigate out this. They are not aware, they don't have time.
That is the reality. That is the reality.
Reality. They are understaffed and staff is not totally educated on these issues. That is the second, yeah.
Yeah, so it's like that in Dubai, you cannot do any business without trade license. So I was telling अरे ये transaction वो transaction तो बोलते हैं कि हम लोग को policing नहीं करता है इधर चलता है, कोई पूछेगा नहीं, तो पूछ लिया तो फिर पकड़ा गया. So something like that we are in limbo at present.
No, then professionals are advising compounding करने वालेंगे. This is the advice of professionals.
Dipti, so long as nothing happens, you don't tell them. There is a proverb, "Aao bul mujhe maar." You don't say that. Not quite. That's how.
Even in education, all these foreign institutes fully come in India, do full business and tell students to move money to lakhs of rupees outside India, crores of rupees.
Exactly, it's a marketing, it sells to people.
All foreign universities are registered in India? I don't think so.
Exactly, they have not taken this. उनके आंख में आया ही नहीं है provision. They require. And
But those
according to
foreign-
me,
those
why it
univers-
should not be, Ashutosh? Why it should not be? Your so many students are going based on this representation. You are earning so much money. What you are doing? What is your university? It should be protected. This require registration.
But they are not companies, no? But Dipti, this registration is of a company incorporated abroad, no?
Outside India, right?
Yeah, but those universities are not companies, most probably.
It can be, sir.
It can be. Yes, it can be. It can be.
It can be, sir. I'll tell you, sir. For example, Manipal, Malaysia.
Okay.
All sections get triggered. Indian subsidiary owning more than 50% company.
Yeah, compliance this, and honestly speaking, like suddenly government has come into picture for Foreign Contribution Regulation Act. I have in mind that this will come into picture in their eye. Somehow.
Yeah, it will
Something
happen.
should come, then it will happen.
Yeah, it will happen. It will happen.
Something will happen at that time, it will come.
But Dipti, then there are another clear case. I know one of my nephew who has studied in this Vidya Alankar Matunga, I think Badala. So in the engineering course of 4 years, 2 years he has to do it here, and then 2 years they have tie up with 2 or 3 universities in US, and you have to select out of those 2 or 3 where you want to complete your balance 2 years. So then in this definition, it is clearly an agent, because the moment you have taken admission here for a 4-year course, wherein half you do here and half you do there, and you are paying fees there, so that is clearly an agent. but they don't have
Yeah.
any registration.
Yeah, of course it should have. Now you are understanding it required, right? It's a proper business transaction. And see the level they have gone. That even if you do marketing, data churning or anything, it's a business activity.
Yeah, so good thing is that Bollywood doesn't come here to promote their movies. Otherwise, that's clearly for doing business. Like when any Indian movie is to be released, they go to Delhi, Calcutta to promote their forthcoming movie. So it is nothing but for soliciting business.
So when lot of company will start coming and doing business, this is going to be triggered. They will control everything.
Yeah.
And they will come with that notification. But at present, yes, it's limbo.
Yeah.
But if you comply with and do it, if you can, and there is a good thing. Okay, there are other questions. Let's take it. With example, directly Facebook through agent, Tata Sons, SIA, physical, any other manner through subsidiary, same thing. Then the question from Mr. Pradeep Parag. Considering the omitted definition of foreign subsidiary under Companies Act 2013, will an overseas holding company not be covered in the definition of foreign company and will not be required to obtain FCINR and comply with other filing requirements? Since foreign subsidiary company definition is deleted in Companies Act 2013, overseas holding company should be covered as a foreign company. That is his question. Anand?
That's what I said. If it's just a holdco company, but it doesn't have place of business in India, it should not be covered.
Yeah, correct.
Exactly.
How the law will, yeah.
But even if you look at those definitions, like I mean, subsidiaries in India, and it must be definitely having some business connection with overseas holding company. But then the purpose of the act is that you don't do any business without getting properly registered. Now here your subsidiary is properly registered, reporting, filing annual accounts. So I don't think their purpose is to just catch those who are coming doing business and not reporting.
It's like your UBO, what we have learned. Whether shareholders can be determined, don't report. If your shareholders not can be reported, you have to report UBO to SBO, what we say under MCA, right? Okay, jahan nahi malum hai report, government wants to know who the guy behind it. Same year, who the guy you are, who's doing business in India. But if you have registered subsidiary, everything can be catch up on, then it's not an issue.
I'll put that for my understanding, my view that deletion of foreign subsidiaries, just they have deleted that definition, but that doesn't mean that subsidiary of foreign company it is not subsidiary. It's that definition only they draw. But if there is a subsidiary of holding company overseas, then it is still subsidiary company. And our question then remains is whether that holding subsidiary will be foreign company or not. Whether subsidiary or holding company located out of India and having subsidiary or holding company in India, whether that foreign company require FC or not. The same question we can put it here. And that we have discussed already.
Yeah.
How the law will be enforced in case a foreign company having a place of business in India through electronic mode refuses to register as per the provisions of the new act and also refuses to pay the fine. Let MCA understand that.
No, that's exactly the challenge, Dipti, with this
Exactly.
new technologies. Like assuming Amazon is only there and all we are buying on the Amazon websites. Definitely there is a business. So now technology has given a challenge to lawmakers how to catch them either for reporting or for paying tax over here.
Basically, how they will come to know that they are there are so many websites and the people who are offering. How they will know that Indian people they are giving and it's available? Then every company having website and allowing option to online purchase portal, that platform is subject to this FCAR registration. Simple. That way. Whether people purchase or not, if they give option and that is available to Indian public, it's a place of business.
No, but in such a situation, can there not be coercive measures such as please stop doing business in India? If you do business in India, all your persons who deliver goods to the houses will be arrested. Some coercive measures can be introduced, and also refuses to pay the fine.
So, sir, at least RBI circular is very clear. If you see established of business in India, that you need to register in India if you are outside company coming in India. Same like what we do. If you go to Dubai, we cannot do it without registering with DFC or that.
Right.
And that is that FCRN number which is there in that circular.
So how the law will be enforced? I think there could be various ways of doing it.
Yeah,
various coercive methods of doing it. Coercive methods. Impound their assets, impound their monies. I don't think you can just escape because they are doing the work electronically. After all, a person comes to your home to deliver something. You pay money into their account. Lots of coercive measures can be put in.
So, let MCA decide, even though they are knowing many things, they are not able to do it. So that let's leave it to MCA now. Now, next question, for example, if company incorporated in Russia conducts vaccine or drug trial in India as part of R&D, then whether such company will come under ambit of foreign company provision and regulation governed by Companies Act 2013. They are just conducting trials. They don't have any intention of manufacturing in India after successful drug trial panel.
So first of all, because come to definition of business first. Are they doing business? Are they making profits or revenue out of that? First, that is there are various research who come to India, and we also go outside India for research. That doesn't mean that we are doing business.
Exactly. For example, Indian company wants to introduce new product in US market. They have to sometimes complete these clinical trials in those countries because the temperature, climate is different. So whether medicines will have the similar effect or no, unless you prove this, they will not give you a permission to launch your product in those countries. So I don't think there's a business connection will start thereafter. This is a pre-approval activity. Once you do this, you will get approval and then your business may start.
Correct.
Brinda, correct me, in this case also, if same case Russian is coming to India, first of all, I need to be owning more than 50% to do registration. Then the registration formalities get triggered, right? One is it's a foreign company, yes, that's a definition. But registration, all that, at least whatever, apart from prospectus and that stuff, but other sections gets triggered only when I'm holding more than 50%.
No.
Brinda, you. So compliance for the Russian entity, which we have established is a foreign company because it has a place of business, it has to comply with these sections. The registration part, the submission to ROC, these sections, they anyway have to comply, whether, irrespective of what the shareholding pattern.
Yeah, whether it is 50% or less, they have to comply with that.
So as soon as that 50% shareholding gets hit, these 5 sections become additionally applicable.
Understood.
Okay. Now, next question. One company of UK has incorporated its wholly owned subsidiary in Mumbai, and the company has its registered office in Mumbai. Whether wholly owned subsidiary will be foreign company and all compliance will be, he is confused. It is wholly owned subsidiary is an Indian company. The foreign company will be UK company. And that we discuss whether it will be or not, and it require clarity from MCA.
But I think, Deepti, in this case, that UK company should not file anything because then it will be all duplication. They to do business, they already have incorporated Indian company, which is complying with your all the local laws, whatever is there.
Yeah, again, the same thing we said that as on today, the MCAs have a lot of holding subsidiary relation company and they are getting accounts. But they never raise the question, boss, where is FCRN number for foreign company? So that means they have deemed to be accepted that you are not required to register. But though there is no clarification, it can be interpreted in either way.
As such, people take care that don't make holding company any business in India because that permanent establishment, income tax, various things get triggered, right? So it's only done through Indian subsidiary and grow. I'm just saying foreign subsidiary. doesn't enter into any direct business in India.
And we presume that since they are getting all the information, and that's why the additional now is not required. They have the company in India where they can catch hold. They can ask the information of overseas company details are also given. So I think it's a duplication, as you rightly said, and that's why they are not asking, but the clarification is at present missing from this section, this chapter as well. Any next question? An Indian company has formed wholly owned subsidiary outside of India. Majority of share capital is held by Indian resident companies. One of the director of wholly owned subsidiary is also Indian resident. Indian holding company has business transaction with the wholly owned subsidiary. Please advise if wholly owned subsidiary established outside India will be considered as a foreign company.
Again, same thing. It has to have place of business in India. Same.
And that's all. Everyone has appreciated, and I appreciate the time and contribution by the panelists, both Ashutosh, Silpi, and our own Mr. Bala and Sailesh Bhai. Brinda, it was wonderful presentation, and she was working hard until yesterday night to work on this. And everyone who needs PPT will be shared with everyone. And thanks everyone for your contribution.
Brinda, my compliments to you. You have done excellently a good job and good presentation, and you explained the things also very nicely. Great. Also.
Thank you, sir. Thank you very much. Really appreciate it.
Very good presentation. Very good presentation.
Shilpa, thanks a lot.
Brinda, are you a trainee or are you a company secretary already?
I'm a company secretary, sir.
Okay, great.
Thanks to all the panelists, other people also.
Shilpi, thanks for your time. Ashutosh, thanks.
Pleasure, Dipti,
My
from
pleasure.
all of you. And I think a lot of clarification has come in this, webinar, and more scope is there to discuss. So let's see. And I think we should represent MCA on certain issues. Actually, it's very important.
Yeah, Ashutosh, thanks a lot for your contribution and time.
But Dipti, on certain matters to invite MCA's attention is like सोते हुए शेर को जगाना जैसा हो जाएगा. Inviting trouble. Abel मुझे मार.
I agree on this.
Ashutosh, क्या करे? MCA को देख के नहीं represent.
No, same thing. I had interpretation. Let me clear my books properly, see my books properly, and then go any representation should be. And so, thank you. It was really this August audience.
Thanks a lot to everybody, because you're really speaking. I got enhanced my knowledge today in some of the understandings. Really speaking.
Wait. Kuvadia Sahib, yes. You wanted to say something.
Nothing. That's all. Only you want to make a representation to Delhi MCA. You will get clarification from policy. I will request them.
Oh, thank you.
Make this thing. That's the only thing which I wanted to say.
So, Mr. As everyone knows,
it was a very good session.
Kuvadia Sahib is ex-RD.
Yes.
Yes, we know.
So we have regulator with us.
Yes.
Ex-regulator. I know the policy departments. I will see that they can give clarification if at all you want to have the clarification.
Thank you.
Thanks a lot. Thank you very much.
Thank you.
Thank you
so much. Thank you.
Thanks, Brinda, for your efforts.
Thank you for the wonderful session.
Thank
On a very technical subject.
Yeah.
Thanks a lot, everybody. Have a good weekend. Stay safe. Take care.
Thank you. Bye.
Bye.